Did you know you can legally skip probate court in California just by how your home's title is written? Let's get into it. So your deed decides whether your family faces court delays or inherits your home instantly. Here are 4 vesting options that help you avoid probate in California, per the law. So first up, we have community property with a right of survivorship. This is for married couples or registered domestic partners. When one spouse passes, the other automatically inherits the entire property. No probate, no court, no paperwork. So let's say Mark and Sarah bought a home titled as community property with the right of survivorship. When Mark passes, Sarah instantly owns the home. Pretty easy, right? Now, this form of vesting also gives both halves of the property a full step up in tax basis under federal and California law. So that means if the surviving spouse sells the home later, they could owe significantly less in capital gains tax because the IRS resets the home's taxable value to its current market price at the date of death. All right, joint tenancy. It's used by friends, family, or co-owners. When one owner dies, their share automatically transfers to the surviving owners, no probate. So for example, let's say 2 brothers in Glendale hold an investment home as joint tenants. When one dies, the other instantly becomes the full owner. But one owner can sell or refinance their share, breaking the survivorship rights. Third up, we have a revocable living trust. So if you title your property in your trust, it completely bypasses probate. So for example, let's say you deeded your home to the Riviera Family Trust. When you pass, the successor or trustee can sell or transfer it to your heirs privately, no court involvement. And then a TOD deed, a transfer on death deed. You record this deed while you're alive, obviously, naming a beneficiary. When you pass, the property transfers directly down. No probate, no delay. So for example, a widow in Ventura records a TOD deed naming her daughter. When she passes, all her daughter has to do is file an affidavit and takes the title directly. The biggest mistake most people make, I didn't mean to rhyme that, their trust says one thing, but their deed says a whole nother. In California, the court, everything I could find on this says the court follows the deed, not the trust. If something happened tomorrow, would your title transfer smoothly or would you get stuck in court?